184.3 unless it can be shown that any fundamental right has been affected by the legislation in question. Therefore, when I make submissions on Article 199 and I address independence of judiciary, those submissions should be treated as having read, treated as my arguments on maintainability. I now, my Lord, proceed to Article 191. My Lord, three questions have emerged, essentially. And my Lords may add if I missed out on something. First is that the principle of Master of Roster is a convention which is rooted in over 150 years of judicial history of the Indian subcontinent. Therefore, and the petitioners had relied on Malik Asad's case and Al-Jihad case to argue that because it has attained the status of a convention, therefore it has to be treated as part of the constitutional provisions, and thus this legislation could not upend and could not change the status of the Chief Justice as Master of Roster. So this is the first question that I intend to address. The second, the 1956 rules, which were in force at the time of commencement of the Constitution, ought to be treated as existing law, and for the purposes of the term law under Article 191, those rules should be treated as the law, and thus the Parliament could not legislate on that matter because of those rules having the protection of Article 268. So this is the second question that I intend to address. Third, and this goes to separation of powers as well, and it was observed yesterday that Parliament has assumed the role of Master of Roster through this legislation. Sorry, this question, that Parliament has assumed the role of Master of Roster through this legislation. So this is the third question that I intend to address. And then, of course, I'd be addressing the right of appeal under Section 5 on the basis of Entry 55 to argue that it is constitutional.
Right of appeal on the basis of?
Right of appeal conferred under Section 5, the question on constitutionality of it, so I intend to address that on the basis of Entry 55, sir. Entry 55. To argue that there is no prohibition under the Constitution to enlarge the existing jurisdiction of Article 185 and extend to judgments and orders arising under Article 185. And lastly, I'll be addressing the question of full court, that whether the possibility or the constitution of full court would deprive some of this right of appeal, and then I intend to address whether this alone is sufficient to declare Section 5 unconstitutional. My Lords and your Ladyship, now I'm going to repeat what all has been submitted. At several places in the Constitution, term subject to law has been mentioned, and more specifically, there are four rights, fundamental rights. Article 14, Article 20, 22 and 28.
14, 20,
22 and 28.
And what about them?
Lord, these rights are exercised subject to law. Now, right to privacy, for example, is subject to law. The Constitution acknowledges, recognizes it. But what it does not say is what that law will be. So the distinction that I'm attempting to draw here is the argument which was made before your Lordship that because Article 191 does not say that it's an Act of Parliament, therefore an Act of Parliament perhaps will not be included in it, or this term law will not cover an Act of Parliament. And I'll come back to the provisions of the Constitution which use term Act of Parliament.
You are ready to exclude 19A?
19A is, my Lord, because I'm only focusing on 19A, of course. 19A, I'll be coming to it.
Similar language, subject to regulation and reasonable restrictions imposed by law.
And I'll be coming to it. I'll be coming to it because the 2017 Act.
So why do you want to
access
exclude it from?
For now, I'm just focusing on one thing, which is that the subject to law as used in 191 in fact confers legislative competence. And I'm drawing parallels between 191 and these provisions, but I will be coming back to Article 19A and such other provisions in, for example, 6.3, Article 6.3 of the Constitution, which also confer legislative competence, and my Lord is aware.
Are you saying that the subject to law used in Articles 14, 20, 22, 28 are of a different species from the term, or maybe not exactly same term as used in Article 19A?
No.
Okay.
What I mean to say is that merely using subject to does not in any manner take the competence away. For instance, Article 6 Clause 3 says that a punishment for high treason will be provided by law. The term is used provided by law, and in Article 19A it says imposed subject to such restrictions or regulations as imposed by law. All of these interchangeably they confer legislative competence, and the 2017 Access to Information Right of Access to Information Act 2017 draws its legislative competence from 19A. It does not draw its legislative competence from any of the entries 1 through 57 of Part 1 of the Federalist or Federalist. The term law, my respectful submission, my lords and your ladyship, is it includes two sources. One would be a positive law, which in this case would be an act of parliament, and the other would be precedents, binding effect of the legal precedents. Generally speaking, this is what the term law has come to be understood in our jurisprudence. And the binding effect of the precedents is duly acknowledged under Article 189 and 201 of our Constitution. But what it does is, it does not exclude an act of parliament. It in a way expands the scope of what can happen. For example, right to privacy, it says subject to law, it does not say subject to an act of parliament. So it can be so that the courts have expounded right of privacy in a certain manner, then those precedents or those judgments of the court will also be treated as having the effect, or this right will be construed in accordance with what the courts have also held. But it does not exclude Parliament's right to make an act. So my submission, lordships, is, and your ladyship, is that the term law as provided in Article 191 does not preclude or does not exclude the Parliament's right to legislate. My lords will notice that this provision has not undergone any amendment ever since the Constitution has commenced, Article 191, and so has the preamble. So while Parliament was acknowledging and making its obligation, imposing an obligation upon itself and all other organs of the state to fully secure independence of judiciary, Parliament at the same time did not give up its right to legislate on matters which may relate to regulating practice and procedure of the Supreme Court. And in my CMA, I have, and I walked your lordship through the history of how the pari materia provision of Article 199 has evolved over the years, and I had submitted that it is in fact the executive's role which was eliminated by the Parliament from this process in 1973, which the executive through the President has had prior to the 1973 Constitution. But what it did not do was, it did not give up its own right.
But if you draw this analogy between what was happening prior to the 1973 Constitution, where the rule-making power was subject to previous approval, Governor General, President, so on and so forth, that power which you say was in the executive branch, and that has now been taken away. Is this, if I've understood you correctly? that power was of what I may call a passive nature. In other words, the President, Governor General could not have initiated rule or exercise rule-making power. It was simply you, Supreme Court, make the rules, but they've got to pass muster with the executive branch before they come into effect. So if this is the analogy that you are drawing, then why ought not the law-making power that you say vests in Parliament in terms of the word law, why should that also not, although it remains there, and as you say it has never ever been exercised prior to this particular act, but drawing the analogy now between the previous approval, why should that also not be regarded in a passive sense, in the sense that it is not an enabling provision, but simply something that Supreme Court has to keep in mind when making rules?
Understood, sir. Barring Government of India Act, all other subsequent constitutional frameworks, constitutions that we have had, there was always legislative power. There were always, the rules were always subject to law and constitution.
Our 56 constitution.
56 constitution, in fact, went a step ahead.
उसकी language फर्क है ना?
जी, 177 said that until an act of parliament is made in this behalf.
That's a different language.
So it was actually, it went a step
But
further.
after, what happens after?
And then subsequently 62 and 72, it says subject to the constitution and the law with the prior approval of the president. So what is happening here is, and barring Government of India,
Government of India Act.
Government of India Act was totally prior approval in his discretion, and that's about it.
No, but Government of India Act did not have any legislative engagement at all.
Yes.
So what I'm saying is, if you look at it in the historical context, and I'm now focusing on the analogy that you're making, that previously there was the executive plus the legislative. The executive was purely passive as far as I can understand. So why should not, on that analogy, the law-making power or the law part of it also be regarded not as an enabling power, but as a whatever restrictive, limiting power, or whatever, in whatever sense?
One reason perhaps could be that till 1972 or when the 1956 rules were made, because there was a prior approval of the president already there, the legislature chose, and in fact, in 1956, because third schedule applied, until such time it applied when the parliament actually made these regulations, to the exclusion of, in fact, the Supreme Court under the 1956 constitution, it did not. So there was, the parliament chose not to act. What I am submitting, my lords, is that parliament's choosing not to act or choosing not to